Well, good morning attendees and welcome to a webinar on arbitration in the COVID-19 environment. We do apologise for the delay in starting this webinar. As can happen at this time, we've had a few technical difficulties with Wi-Fi connection. One of the joys of working in this environment is that none of us had the ability beforehand to make sure that we had sufficient bandwidth for everything we needed to do, and lack of bandwidth can be a bit of a problem in more ways than one. So good morning to you all. My name is Sue Wells and I'm the Executive Director of the Arbitrators and Mediators Institute. I'm joined this morning by some absolutely outstanding presenters, the Honourable Paul Heath, QC, Dr Anna Kirk and Nicole Smith, who are going to discuss with us tips and techniques on arbitration in the COVID-19 environment. Paul, without further ado, I'll hand over to you and let's get this webinar underway.
Okay, thanks very much, Sue. In December last year, none of us had heard about the expression COVID-19. Perhaps we had heard something about what was going on in Wuhan and may even have heard the word coronavirus. Our knowledge may have heightened a little in January and probably more so in February, when the virus started to engulf China and later Iran and Italy. By 15 March, our borders had been almost fully closed, and now we are all living in a state of lockdown where we must live and work within our bubble and go outside only for essential work, supermarket shopping, medical needs and exercise. 1 week to go, hopefully, now day 22 of lockdown, or for some of us who are silly enough to go overseas and arrive late, day 29 and into the 5th week. I can tell you the 4th week's not as bad. So how much has New Zealand changed since mid-March? What has happened is likely to save many lives and also allow us to return to something approaching normality more quickly than other countries that did not take as stringent measures as we did in a timely fashion. But the consequences have been huge. The economy is slowing almost to the point where many businesses have come to a standstill. Problems will undoubtedly arise, as they always do in any recession, when creditors want their money and debtors cannot pay them. Such disputes require prompt resolution. For example, some people will argue that contracts have been frustrated by the pandemic and the government's response. Others may raise force majeure arguments to avoid the need to comply with contractual obligations. And I'm sure that more creative points will also be taken. The need for urgent resolution of disputes has never been greater. While the economy will take a long time to recover, the one difference in the present recession is that many businesses have good underlying fundamentals and have only got into trouble because of strains on liquidity due to events well beyond their control. So the question for us is, how do we go about assisting the business community to resolve their disputes promptly and to enable normality in the business sector to resume as soon as possible? The three of us will talk to you today about various options to resolve such disputes by arbitration in an efficient and effective way. After I finish these introductory words, Nicole Smith will talk to you about how to commence an arbitral process quickly in order to take advantage of all available options. I will then talk about the concepts of preliminary orders and interim measures that are available to an arbitral tribunal. Anna Kirk will then talk about the role of an emergency arbitrator and what he or she is empowered to do. At the end of our respective presentations, which will take about 15 minutes each, we will engage in a discussion among ourselves as to the best way to structure an expedited arbitration designed to determine promptly the substance of a dispute. What is important is that an expedited arbitration requires all the parties to want to have the dispute resolved quickly. We will outline templates for urgent arbitrations of that type. We will discuss alternative ways of hearing such disputes, given our likely inability for some time to hold orthodox arbitral hearings at which multiple counsel may attend, together with parties, witnesses, and stenographers. After we've finished that internal discussion, we'll then take questions, and Sue Wells will moderate those. Alternatives do need to be found and embraced by those engaged in arbitration. With the best will in the world, the courts will have difficulty in responding to requests for urgent hearings, given the backlogs that have inevitably arisen in both criminal and civil proceedings as a result of the level 4 restrictions. We will discuss options for such hearings and the way in which arbitral tribunals can, in harmony with counsel and the parties, structure them in a manner that facilitates a fair hearing which complies with the rules of natural justice. So at this point, I'll throw over to Nicole Smith to talk about the commencement of the arbitration and the appointment of arbitrators. Nicole.
Thank you, Paul. First, I want to look at commencing an arbitration and appointing an arbitrator. So I've seen the list of attendees and I can see that a lot of you are very experienced in this area. So I hope I'm not going over too much ground that's completely familiar to you, but I think it's good to go back to first principles and then look forward to the other steps you can take in to get an arbitration through urgently or to help you in these COVID-19 times. So we need to remember that arbitration is a consensual process. So there are two routes to arbitration. The first is where you've agreed to submit future disputes to arbitration. So for example, in the dispute resolution clause in your contract, or the other option is that you can agree to submit a dispute to arbitration once a dispute arises. You can't require a party to go into an arbitration process if they haven't already agreed to do so in the contract, or they do not agree to do so once the dispute arises. So the vast majority of arbitrations we deal with fall into that first category where there's already a provision in a contract. But in this new environment, and given the potential delays in accessing the court system, we're expecting a strong uplift in the number of cases where parties agree to submit a dispute to arbitration, often referred to as a submission agreement, after the dispute has arisen. First, I'll consider the process where you have an arbitration agreement, and then the options as to what to include in a submission agreement in order to commence your arbitration. So how do you commence an arbitration? I know this will be familiar to most of you, but it is helpful to go back to these first principles. And we also need to think about how lockdown at level 4 and at lower levels affects our ability to commence an arbitration. Because the situation is constantly evolving with arbitration institutions issuing new protocols and amendments being made to court rules and the processes. And we certainly don't claim to have all the answers. So it'd be interesting to hear from others at the end of the presentation as to ideas you have to work through setting up arbitrations and getting things moving. Obviously, the first thing you have to do is to check your contract. You need to check whether there are any preliminary steps that you need to undertake, what it says about giving notice, and what it says about appointing the tribunal. So looking first at preliminary steps. In their dispute resolution provision, the parties may have agreed that prior to commencing an arbitration, they will, for example, hold negotiations between executives or attempt conciliation or mediation. And unless the parties agree to waive those steps, you need to make a genuine attempt to complete those prior to launching into arbitration. So for example, if your contract refers to a meeting between senior executives, in the current environment, I think a request for an online meeting or a phone call, that should be sufficient to show that you have attempted to move through that prior step. giving notice to commence. Once again, look at what your contract says. Are you required to serve documents in a particular way? Even if your contract requires you to deliver documents by hand or by courier, in the current circumstances, it is likely to be sufficient in order to get the arbitration started to notify your request for arbitration by email, follow it up with a phone call. But the main thing you're going to have to show is that you have sent it to somebody within the company with authority to effectively accept service and to get the arbitration started. And what I do in a number of arbitrations where the other side is recalcitrant or trying to avoid service or not wanting to engage, even where we have an online process agreed in the arbitration provision and in the contract, is I use the Microsoft Outlook request a delivery receipt and request a read receipt. So that way you have some evidence to show that it was a valid email address, that it was delivered, it wasn't blocked, and if they are willing to open it and read it without blocking your read receipt, then you can also use that. But once you are getting through to get an actual award, and once lockdown lifts, I would strongly recommend going back and repeating whatever processes are in your contract. So send everything by courier again after you've got things started, or make sure that in the first procedural order, the arbitrator gets both parties to confirm that they have no objections as to service and how that was started. Because even if you send something to a valid email address, in this day and age, there's a chance that the password to that email address is written on a yellow sticky sitting on the screen of the executive in their office, and they have no idea how to access it. And the IT guy has never seen it and doesn't know the name of their first dog or their favorite teacher. So, you know, the old-fashioned pick up a phone can be a way to get through to people. So if your contract incorporates the rules of an arbitration institute, then you need to check those rules for what is required to commence the arbitration, and you need to check whether the institute has issued a new protocol or interpretation of those rules for a COVID-19 environment. So for example, the ICC has issued a guidance note, Chartered Institute has just put one out. But if your arbitration provision just refers to arbitration under the Act, then you go to Article 21, which has just been brought up on the screen. And that provides that unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. You should also look at Schedule 1, Article 3, which refers to receipt of communications under the Act. And if you look through that, you can see that it assumes delivery of hard copies. And only if you can't achieve that after making reasonable inquiry can you go to another means, such as which requires a record of the attempt to deliver it. So I would say that in the current environment, it would be acceptable to get an arbitration started to send the request by email, but make sure you get some kind of acknowledgement that you've done so in order to move forward. As far as the form of the request for arbitration, unless you're under procedural rules, in which case go to those, look at what you need to have in your request. There's no particular form. Just make sure that it refers to a particular dispute, so the other side knows what it is you want to arbitrate about, and say that you're requesting that that dispute be referred to arbitration in accordance with the provision in your contract. Now, appointing the tribunal. If your arbitration agreement contains provisions as to how you should try to agree on the arbitrator, then follow those provisions. may provide for an entity such as ADLS or AMINZ or NZLS to make the appointment, or it may provide for a 3-person tribunal with each party appointing somebody and then those two appointing the third. If the arbitration agreement is silent on the appointment process, then you follow the procedure in the Act. You see Article 10 there. In the case of an international arbitration, it's 3. In every other case, it should be 1. Article 11 assumes that the parties will first try and agree on who they want the arbitrator to be, but if they are not able to agree, or if one party fails to appoint, then you go to the appointed body. You can see that in 11.3 A and B. So very important to know the appointed body is now AMINZ. That has been specified by regulation. It's referred to in the Act. It's no longer the old situation and the situation in many countries where you had to go off to court if your arbitration appointment provision wasn't working. So your appointment request should be sent to office@aminz.org.nz. AMINZ staff are currently working remotely, but that email address is being monitored. And then we've got up here the information that AMINZ wants you to include in order to allow them to make the appointment, and also pay the appointment fee of $500. And the aim is to make the appointment within 3 working days. The process for appointing an arbitrator by AMINZ is set out on the website. It involves the AMINZ office sending details of the request to a number of representatives on the AMINZ appointments panel. And the members of that panel are also on the website. They make a recommendation to the AMINZ appointing officers, and the parties are advised of the person appointed. So that's the process you go through where you have an arbitration provision in your contract, and that is therefore the dispute resolution process that you must follow. In the current environment, there could well be situations where parties have no dispute resolution provision, and therefore their default option would be to go to court. While the courts are looking at ways and means of running remote hearings, they will make their own assessments as to what is urgent, what has priority, and they may not necessarily be the same views that the parties have. So if you have 2 willing parties who think that they want to get their dispute resolved and they don't think it's going to work for them to stand in line at the court, then they can agree to submit their dispute to arbitration. If that's what you want to do, there's no magic form to that. You can just do that by an exchange of emails. Make sure that the person agreeing to that has authority to bind the company. You need to agree on the process for appointing your tribunal. You could agree to exchange a list, to follow the process in the Act. You can appoint someone you've used before. You can look at the AMINZ panel, or you can ask an entity to make the appointment, like AMINZ or NZLS or NZDRC. If you've got a larger or more complex arbitration, you may want a registry function. So spoken to NZDRC, and they are prepared to do that for ad hoc arbitrations, as well as for arbitrations under their rules. So that means they can handle the financial aspects of deposits and payments of arbitrators' fees. They can arrange remote hearing facilities, conference calls, that kind of thing. If you're not feeling comfortable with running that yourself, they can assist you with that. And they've also got a new process for the no access disputes that we're likely to get coming up under the provision in a number of lease agreements, but particularly the ADLS recent form. So if you're agreeing to do it directly, you're not using a third party, independent third party to make your appointment, then you need to contact the arbitrator. You need to check they don't have any conflicts. You need to make sure they're going to be able to be impartial and independent and available. the best way to do that is by email with the other side copied in and agreeing on what the content of that request to the arbitrator says. I know that everybody thinks that they are describing their dispute in a really neutral way when they call up an arbitrator to see whether they're available, but your version of neutral may not be the same as the other parties, and it's best not to get off on the wrong foot by having presented arguments to an arbitrator without the other side present, because that could lead to arguments later that there was a failure to observe due process and natural justice. If the arbitrator decides to accept the appointment, they're likely to send you their terms of appointment, including their fees or hourly rate. They may ask you to pay funds on account of their fees into their solicitor's trust account if they have one, or into your own solicitor's trust accounts. AMINZ has an arrangement with a trustee company for stakeholders, or for example, NZDRC can manage the fee process for you if you're going to do it that way. So I'll now hand back to Paul for an explanation of interim measures and preliminary orders that can be granted by a tribunal.
Okay, thank you, Anna. The picture you see is taken from that well-known case of David against T-Rex and requires very urgent relief. So how do you go about that in circumstances where your tribunal has already been constituted or where you need to have someone appointed specifically to do it? A preliminary order is the equivalent of a without notice injunction in the High Court. An interim measure is the equivalent of an on-notice injunction issued by the High Court. A preliminary order and interim measure can be ordered by a constituted arbitral tribunal or by an emergency arbitrator appointed for the purpose. I won't say any more about emergency arbitrators, as Anna is going to explain their role and functions shortly. If the parties have entered into an arbitration agreement but have appointed neither an arbitral tribunal to determine the substantive dispute or an emergency arbitrator, any issues of interim relief will need to be addressed by the High Court. Article 9 of Schedule 1 makes it clear the court is entitled to assist on matters of interim relief where a tribunal has not been constituted. Until such time as either an emergency arbitrator or a tribunal has been appointed to determine substantive issues, the only recourse for urgent relief is to the High Court. If a party were to apply to the High Court for interim relief, the court may exercise jurisdiction to grant, without notice or on notice, interim measures of the type that can be ordered by an arbitral tribunal. Provisions dealing with interim measures are set out in Articles 17 through to 17M of Schedule 1 to the Act, which apply in the absence of agreement of the parties to the contrary. The ability to grant interim relief extends to a preliminary order, but that is more limited in the way it operates. A preliminary order is defined as one which directs a party not to frustrate the purpose of an interim measure. In other words, such an order holds the position until both parties can be heard on an interim measure application. An interim measure is then temporary relief after hearing from the parties, designed to maintain or restore a status quo pending determination of a substantive issue. The term interim measure is defined by Section 17 and sets out the type of relief that can be granted. Article 17B sets out what must be established before an interim measure is granted. If we look at 17B first, the applicant must satisfy the tribunal that harm not adequately reparable by an award of damages is likely to result if the measure is not granted, and the harm substantially outweighs the harm that is likely to result if the measure were granted, and there is a reasonable possibility that the applicant will succeed on the merits of the claim. The grounds are similar to, but not identical to, the basis on which the High Court will issue injunctions. If we could just go back to Article 17 for the moment, that explains the definition of interim measure and identifies the type of relief that can be given once those prerequisites have been established. And that's maintenance or restoration of the status quo, action to prevent or refrain from taking action likely to cause disruption or imminent harm to the arbitral proceeding, providing a means of preservation of assets, preserving evidence, and giving security for costs. So those are the bases on which that can be done. Preliminary orders are dealt with by Articles 17C to 17G of Schedule 1. I'm not going to go through them in the same way, but they may be issued at the same time as a request for an interim measure. A preliminary order will only be made if the Tribunal considers that prior disclosure of the request for the interim measure risks frustrating the purpose of it. An applicant for a preliminary order must satisfy the Tribunal of the same matters to which Article 17B refers in relation to interim measures before a preliminary order can be made. So if we can just put up Article 17B again, just to show what they need to be. After any preliminary order has been made, notice must be given to the party against whom the interim measure is sought, and that order then inures for no more than 20 days after the issue. The order is binding on the parties, but not enforceable by a court, and does not constitute an award. Like an interim measure, a preliminary order may subsequently be modified, suspended, or cancelled. A party seeking an interim measure or preliminary order must disclose to the arbitral tribunal all relevant circumstances that are relevant to the tribunal's decision whether to issue or extend the order. And that provision merely reflects the duty of candour on those who certify without notice applications in the High Court. In the case of a preliminary order, security for costs must be given, while that is discretionary on an application for interim relief itself. So that is the general statutory framework against which applications for interim relief can be made in advance of a substantive arbitration hearing. As indicated, such orders can be made either by a duly constituted arbitral tribunal or an emergency arbitrator of the type that Anna will now explain and discuss. So Anna.
Thanks, Paul. And morena, everyone. So Paul has just outlined the interim relief that is available in the Arbitration Act, and what I'm going to discuss now is the mechanics of accessing that relief prior to your arbitral tribunal being constituted. So of course, traditionally, as Paul has explained, if you need urgent relief as soon as your arbitration has commenced, your only option was really to go to the High Court to seek that relief, unless you could get your tribunal constituted very quickly. And for a multitude of reasons, parties may not want to go to the High Court or be able to get their tribunal constituted quickly. So really the concept of an emergency arbitrator emerged around 2010 in order to plug this gap. Emergency arbitrators are effectively temporary arbitral tribunals, and they are appointed to provide urgent interim relief until the permanent tribunal can be established. It means that a party can access the interim relief that Paul was talking about without having to go to the High Court. So what I'm going to do over the next 10 minutes or so is give you the who, what, when, where, why and how of emergency arbitrators. And I appreciate, as Nicole mentioned, that many of you may well have dealt with this on a number of occasions and be very familiar with it, but there's no harm in going back to first principles. So my first question is the why question. Why would you want to opt for an emergency arbitrator rather than just go to the High Court? And there are a number of reasons why you might want to do this. The first is it preserves a single forum. The parties have opted for arbitration as their dispute resolution mechanism. And appointing an emergency arbitrator for interim relief respects this choice, it preserves that choice. And it means that the interim measures are all contained within the one process. And the permanent arbitral tribunal can deal with those measures once they come on board, and I'll talk about that a little bit later. It also preserves the benefits of arbitration for the parties, and this includes the flexibility of procedure. And this might be quite important in the current times, where, as Nicole mentioned, it may be difficult to get access to the courts, and certainly tailoring your process and your general procedure within the lockdown conditions might be quite important to the parties in order to get a quick result. There's also expertise. Emergency arbitrators are usually appointed for their expertise in this field. You will have one emergency arbitrator that deals with your whole application. And of course, that's not guaranteed if you go to the High Court. You may end up with more than one judge dealing with your application, depending on how it plays out. And of course, there's no guarantee if you go to the High Court that you will get a judge dealing with your application who is a particular expert in your area. Confidentiality is another reason that might be important to some parties. Obviously, once you've gone to the court, the fact of your dispute and the nature of your dispute will be in the public domain, and confidentiality will be lost. Speed is another point. Now, obviously, you may be able to get interim relief quite quickly from the courts, particularly in normal times. At the moment, as Nicole mentioned, there's no guarantee that you will get that access to the courts quickly. We're just a bit uncertain about that. And typically, you will get your emergency relief application dealt with within around 14 days by an emergency arbitrator. And I'll talk about the timeframes a little bit more coming up. But certainly, even in lockdown conditions, that timeframe will be preserved in an emergency arbitration, whereas you may have a little more difficulty with the courts. And I've put a last point up there on the slide, which is possible reluctance of the courts to issue interim measures in support of an arbitration unless it's really, really necessary. And this is not an anti-arbitration thing at all. It's much more a reluctance to interfere with the arbitral process that's been seen in some of the cases at the moment. And it follows some reservations that have been expressed in the English courts. And I have a judgment here of Smith Elements in the EPI group, which was a judgment of Justice Wiley from 7th of March 2018. And this was an application for urgent interim relief under in support of an arbitration. Obviously, before the tribunal had been constituted, it took 3 months to decide this application, and there were 3 judges that dealt with it overall. So I'm just going to read a few paragraphs from the end of Justice Wiley's judgment. And these are paragraphs, it starts at 39. And what Justice Wiley said was, were I to succeed to the parties' wishes and deal with the matter, I would be cutting across the jurisdiction of the arbitral tribunal to be appointed by the parties. I accept that an arbitral tribunal has yet to be appointed. And while that could, in some circumstances, justify a court in granting an interim measure to preserve the status quo, I am not satisfied that it does so in this case. Both parties have delayed in appointing an arbitral tribunal, and neither offers any explanation for this. If they had wished to do so, they could have appointed an emergency arbitrator to deal with the interim measures sought. They have not done so. Both parties have entered into an agreement which puts in place comprehensive dispute resolution procedures. Neither has waived the requirement to go to arbitration. Both say they still wish to do so. They have entrusted their dispute to the arbitral tribunal to be appointed, not to this court. In my judgment, in the circumstances of this case, I should refrain from making any further interim orders. So that might be something to consider when you're thinking about whether or not to opt for emergency arbitration. Okay, moving to the second question. This is my how question. How can you access an emergency arbitrator procedure? So access to emergency arbitrators is not automatic even if you've agreed to go to arbitration. So the parties must specifically agree to the emergency arbitrator procedure. And how do you do that? Well, the key is in the Act, and I've got up on the slide there, section 2.1 of the Arbitration Act. And this was an amendment that was put in 2016. And effectively, emergency arbitrators are now part of the definition of an arbitral tribunal, and you see that in point B. So an emergency arbitrator can be appointed under either the arbitration agreement that the parties have entered into, or any set of arbitral rules that the parties have agreed to adopt. So most arbitral rules that are commonly used internationally include emergency arbitrator procedures. So if you've adopted one of those, then you've got access to that process. The AMINZ arbitration rules also have an emergency arbitrator procedure. The NZDRC rules don't have emergency arbitrators per se, but they do have their own urgent relief provisions. So if you're under those rules, have a look at those provisions and see how they apply. Of course, many New Zealand domestic arbitrations don't occur under institutional or arbitral rules. They just happen under the Act and apply the provisions of the Act. And this means that parties would not be able to take advantage of the emergency arbitrator procedures unless they specifically agree to do so. Now, it's unlikely that parties will have agreed to do so within their arbitration agreement if that's contained in the contract. I have never seen emergency arbitrators referred to in a contractual clause. That's not to say that they aren't, but I dare say it's not too common. Maybe it'll become more common in the future. But for the most part, it would need to be agreed after the dispute has arisen, essentially in a submission agreement of the type that Nicole was talking about earlier. And that's the situation that Justice Wiley was talking about in that case that I just quoted from, essentially saying that the parties could have opted to agree to have these emergency arbitrator procedures. And such an agreement can be quite short and simple. AMINZ has an emergency arbitrator protocol on its website that's separate from its rules, and this could be adopted if parties wanted to, or the agreement could specify its own regime, and we can certainly discuss that in a little more detail in the panel discussion a little bit later. Okay, let's move to question 3. Question 3, hopefully it'll come up on the slide, is my when question. Here we go. So when can you commence an emergency arbitrator procedure? Well, obviously, it should be before your arbitration tribunal has been appointed or established. It's not necessarily before the arbitration has commenced, and that depends on your agreement or your rules or your protocol that you're operating under. So you just need to check that. For example, the ICC rules allow urgent relief to be applied for prior to the arbitration request being filed, so long as that request for arbitration is filed within 10 days of an emergency arbitrator being appointed. The AMINZ rules say that you can file a request for an emergency arbitrator concurrently with your request for arbitration or any time before your tribunal has been appointed. So really the key is just to check what your regime says. Question number 4 is a what question. What can an emergency arbitrator do? Well, as I mentioned earlier, under the Arbitration Act, an emergency arbitrator is defined as part of an arbitral tribunal. So they essentially have all of the powers and the obligations of the arbitral tribunal, and they can grant the interim measures and the preliminary orders that Paul discussed earlier, those contained in Article 17 of Schedule 1. And that includes the preliminary orders on an ex parte basis. So the next question is my who question. Who is your emergency arbitrator? And this is effectively the appointment process. So first of all, obviously you can agree on who your emergency arbitrator is going to be. I don't think this is very common. It's far more common to go to an appointing body to get your emergency arbitrator appointed. And you need someone who's going to be able to do that quickly. And Nicole explained earlier the appointment process, and it's essentially the same for an emergency arbitrator. So you may have agreed an appointing body, or it may be AMINZ as the appointed body under the Act. Obviously, as this is quite a specialised appointment and there is a need for speed, you want to choose someone as your appointing body who understands the procedure and knows what to do in those circumstances. If you go to AMINZ, AMINZ will appoint your emergency arbitrator within 48 hours. You also need to think about what you need to put in your application for an emergency arbitrator, and again, you'll need to look at your agreement or the rules that you're operating under just to check that you've got everything. For the most part, you usually need to supply something like the request for arbitration if you're filing concurrently, or some sort of summary of what your dispute is about, particularly if you're filing before your arbitration has officially commenced. You'll need to specify the interim measures that you're seeking, and the reasons why you're seeking them, and the reasons why they are urgent. You need to provide a copy to the other party or parties, or you need to explain to the appointing body why you are not. And obviously you need to pay any fee associated with it. Okay, question 6. It's another what question. I took the liberty of putting 2 what questions in there. So what is the procedure? Once you've got your emergency arbitrator appointed, what happens next? So as I mentioned, emergency arbitrators are arbitral tribunals under the Act. They have the same procedural powers and duties as regular tribunals, and that includes impartiality, independence, the same framework of natural justice, due process and fairness that they need to operate under. The procedure is flexible and it can be shaped to suit your dispute. But of course, if you're operating under a protocol or a set of arbitral rules or even an agreement that prescribes a certain time frame in which the emergency arbitration must be concluded, then you need to stick to that time frame and shape your timetable to suit it. And as I mentioned earlier, most sets of arbitral rules or protocols that apply tend to adopt a 14-day time period by which the emergency arbitrator's award must be issued. So the likely procedure is that there'll be a telephone or a video conference within a day or two of the appointment of the emergency arbitrator. During that conference, a timetable will be set, which will give both parties a chance to make submissions and provide evidence in support of their positions. There may or may not be a hearing. A number of the institutional rules encourage telephone or video conference hearings, which is interesting. That was quite apart from a COVID-19 environment that was encouraged anyway due to the short timeframes. And then, of course, your award is issued. It's issued with reasons, usually, unless the parties have agreed otherwise. And I use the word award deliberately because any interim measure award issued by an emergency arbitrator is an award under the Arbitration Act. It's enforceable as an award under the Act. It's enforceable internationally, although I put a little bit of a query beside that because there are some issues with emergency arbitrator awards under the New York Convention, although many domestic regimes like ours have dealt with that by amending their acts. So, but you might need to just get an opinion if you're trying to enforce internationally. Once your emergency arbitration procedure has finished and your arbitral tribunal is appointed, that permanent tribunal can then look at those interim measures and they can adopt them, they can vary them, they can revoke them. So it keeps, as I said at the beginning, the interim measure procedure within the context of the arbitration as a whole, and your permanent tribunal is then able to pick that up and deal with it themselves. All right, final question. Question 7 is the where question. I didn't really have a where question, but this was a nice segue into the next discussion. So where is the hearing held? And there I put online ? And basically the message is that it's relatively easy to hold emergency arbitration hearings online. They should be shorter, simpler hearings in any case. And certainly, as I've said, the timeframes for emergency arbitrators to decide the issues aren't changed under lockdown conditions. So this process will work very well and possibly much better than the court process within the context of lockdown conditions, and probably still within the conditions we might face following the lifting of the level 4 lockdown, where we're still probably going to have quite a long time where we have restrictions on us. So it makes emergency arbitrator procedures a very viable and perhaps preferable procedure to going to the High Court in these rather uncertain times. Okay, and with that, I'll give it back to Nicole.
Thank you. The next topic we were going to look at is the process of having an urgent arbitration or an expedited arbitration and getting things done in this lockdown environment. We don't really know what level 3 is going to look like or really where things are going to move on from there. So we were talking about the options for getting an arbitration through quickly without the long time frames that you might certainly are going to expect from a court proceeding, and that you might, the more medium term time frame that you might have in an ordinary arbitration. So I guess one of the questions that parties need to look at is whether it is correct that the decision that they want, or the issue that they need considered, is urgent and does need to be expedited. Take a pause and step back and consider whether, it might be appropriate to get things started, but do you really need to rush through to get a decision? And I think the phrase used by our Prime Minister a couple of days ago is probably a good test for everyone to use. Are you being a good human being? Pause and think about that. Because these are times when there may well be power imbalances and everybody is probably fighting a battle that you don't know about within their own bubble, or dealing with issues that you don't know about. So I think just to be a good human being means you need to pause and think about whether this is the right process to go through. Anyway, there are going to be some urgent issues that need to be dealt with, or things that you want to get started or get some clarity on so that you can decide how to move forward with your businesses. The obvious one is going to be those no access lease clauses. If you know that you are not going to receive rent from your tenants for the period of lockdown, that may affect the way you approach other things you do in your business. If you find out that you are actually going to have to pay your rent during that period, that may affect the way you move forward. One example that came through from some colleagues of mine in London was quite a good example of where both parties wanted to get something done fairly quickly. So a colleague wrote through saying, I'm acting for a venture capital investors in a travel booking business. Unsurprisingly, the business has come unstuck in recent weeks. It is looking to sell its major asset and to retrench. There is a dispute between the investors and the board as to whether the investors are entitled to a priority distribution from the proceeds of sale. That turns on the interpretation of the articles and specifically a consideration of whether selling a particular asset constitutes a disposal of substantially all of the business. If it does, they get the money out first. If not, they don't. They've agreed that the key thing in the short term is that the deal, i.e. the sale, happens. They've agreed that in principle, most of the sale proceeds can be held in escrow, pending a swift determination of the dispute by arbitration. And there's about £2 million in issue. So there you've got both parties want to move forward with it. They're willing to look at an expedited process, and you can see that they need to make that they're being reasonable about getting the initial sale process done, and now they need a resolution of that issue. That is one where you're probably not going to have to deal with witnesses. It's something that could usually be done in the UK under what we call a Part 8 procedure, where it's just a question of law really, or interpretation of the contract. So that's one example, but you may very well have disputes about investments that are no longer viable, cancellation of contracts because the item ordered is no longer needed. That may be sitting at the docks. What do you do with it? Can you on-sell it? And those things may all require a fairly swift determination. So we discussed that with Paul and Anna, and we looked through the process that you might be able to follow to get an arbitration run on an expedited basis. So I think Paul's got a set of processes that he was going to talk through.
Well, perhaps there are three bases on which the discussion that follows is premised, and I just want to briefly refer to them. The first, as Nicole has said, is both parties need to want to do this, that it is a dispute they need to have resolved quickly, and they're prepared to go out of the way to make sure it can be. The second point is that even in an expedited arbitration, the fundamental rule of equality of treatment continues to apply, and enforcement is likely to be refused if there hasn't been compliance with the rules of natural justice. And when I was on the bench, there was a case that arose out of the expedited arbitration rules that the NZDRC have, and it was on the basis that there was an agreement that some of the findings could be made on the affidavits that were filed without the need for oral evidence. And the question arose as to whether, if somebody had filed an affidavit which had gone further than strict reply, and the arbitrator relied on that, whether that was actually a breach of natural justice because the other party hadn't had an opportunity to respond. And the decision I reached was that it was open to the parties to agree that the arbitrator could decide these matters on the papers, and as long as the arbitrator didn't rely on any of the extraneous material, there was no difficulty in what happened, and I upheld the award. But it does demonstrate that you've got to be careful to ensure that the natural justice component is met. The third point is the complexity of the case will necessarily affect the extent of expedition possible. And in the case we're going to discuss that Nicole briefly outlined, it's a relatively straightforward case, and what we've put together is something that demonstrates perhaps how quickly this could be done with cooperation. So if we can move to the next slide, please. We start with the premise that the parties agree to enter into arbitration and that they've agreed on a sole arbitrator or somebody who's going to appoint one. We're then suggesting a quick case management conference, 3 working days within appointment. And the idea is that at that stage, you particularize the issues so that you really define those carefully, so that everybody is focusing on that when they provide their evidence, etc. The second is the identification of technology, and this particularly applies in our current environment. There have been a couple of court decisions in England, and certainly there is material in some of the arbitration literature that is pointing out the importance of agreeing a platform for conducting an online hearing very early. And this will involve identification of how many witnesses are going to be needed, where the locations are, and whether you've got enough bandwidth to be able to cover all of these things. And it's better to talk about that early on and then make sure that everything's ready for a hearing, rather than talk about it a few days before the hearing when you may not have time to sort everything out. The form of the points of claim and defence are then tailored specifically to the narrow issues that are being determined. And we've added the editorial comment. This is all about transparency, not game playing. Game playing has no place in a situation where the parties themselves want to move quickly. And the point about avoidance of discovery is the same thing. If the parties in the example Nicole gave know that the case is going to turn on the Articles of Association as it is in England, there is that, and maybe a few other core documents both will have access to. An expedited arbitration isn't something where you're looking for a smoking gun and you want full disclosure, because that's just not going to be ordered. Preparation of a comprehensive agreed statement of facts makes it easier to then tailor the evidence around that, because the agreed statement will cover off all of the points that are not in dispute. So then we have the exchanges of the sworn statements tailored to issues and excluding agreed facts, primary and opinion. Work out what the common bundle of core documents is going to look like and fix a hearing date. If we can just move on. Then follow the various directions. So if you think about it, the conference has been held within 3 working days of the appointment of the arbitrator. So the claimant lodges and serves points of claim, briefs of evidence, supporting documentation and submissions all together in 10 working days. Respondent lodges the opposing series of documents within a further 10 working days. Paginated and chronological common bundle, electronic and or paper, another 3, lodged within 3 working days of the hearing that's already been fixed. Any hearing is to take place within a further 5 working days by AVL or part AVL, part person, in a form to be agreed between the parties and or determined by the arbitrator. And the likelihood is that that will all have been resolved at the case management conference. And then the arbitrator provides a final award within a further 10 working days. So what you have is within about 6 weeks, you've moved from appointment of arbitrator to a final decision that is capable of being enforced. And there's not too much in there for the sort of case that Nicole is talking about that couldn't reasonably be dealt with within that time, as long as everybody is focusing on what is important and putting all the surplus material to one side. So that's the idea in terms of the way in which you might structure an expedited arbitration. It's certainly not the only way, and it may be that we're open to discussion on some of those ideas. Nicole.
I think we're going to turn to Anna now and hear from her about some ideas about the process of having a AVL hearing.
Oops, have I...
You're back.
I'm all right. Good. So really, I just had a few points, and they echo very much Paul's words, that the issue with an AVL hearing, particularly if you're going to be all online and not have any in-person elements, is ensuring that you're planning well in advance. If you planned well in advance, then things should run relatively smoothly. So it's at an early stage in the proceedings. If you can, you need to agree your technology, your technological platform. And of course you need to test it. Make sure you've tested it prior to the hearing so that you don't have any unforeseen issues coming up, that people can't somehow work the technology or that it doesn't work on their particular platforms that they've got. So that's very important. From a practical consideration, you need to consider the, and again, I think Paul or Sue or someone talked about bandwidth, making sure that there is enough connectivity there. And whether or not you want to actually use a specialist company to assist you with this. And certainly for more complex hearings, and if you've got witnesses in different locations, I would recommend it. The online hearings that I have been involved in have all used specialist technology companies to help at each end. And then you have tech support on site as well if you need it. You need to consider the level of cybersecurity that you want, and that may well affect the platform that you decide to use. Obviously, confidentiality is important in arbitration, but for the most part, we're not discussing state secrets or top-level classified information. So being realistic about the cybersecurity that you need is important, and coming to an agreement on that. What I would suggest is that you plan slightly differently for your hearing days. So you might want to plan slightly shorter hearing days because it can be quite draining doing this online. And you need to allow a little bit of time for some technological issues to occur. They obviously occurred today when we couldn't quite start right on time. We're 5 minutes late. That may well occur, and it's just a matter of planning for that, so that if it does happen, it doesn't throw everything out. So making sure that you're aware of that. Planning again is important for things like the documents. Make sure that you're clear on how you're going to structure your documents. Having one really clearly paginated or labelled bundle will be very helpful so that people don't get confused or lose the document. Think about whether you're able to have a screen that's shared where the document can be put up so that everyone can see it. That might be helpful for a witness. If you've got witnesses in a different location, how are we going to make sure that they can find the document in the bundle? And it may be that, and it depends on the conditions that we're operating under, obviously, that may be that someone is allowed in the room with them who can help them find the document. It may be that they just need to be very clearly instructed beforehand on how to find the documents. So you need to think about that just depending on the environment. But moving forward, if we're less restricted, it might be useful to have someone in the room. The ones that I've been involved in, often when there's a witness just giving video evidence, there will be a junior from each law firm with that witness in the room, and they can help them find the document and just make sure that everything is okay. The other thing I would suggest is that you agree in advance very clearly who is going to be in each room so that there's no surprises, that there's a very clear list of participants and everyone knows who is in each room, and that you put together a protocol that helps you clearly distinguish all of that. I've seen things like, for example, protocols that say the witness must be in a certain position. You must be able to see the desk in front of the witness, for example. So it's little details like that that just help it run smoothly. And again, who's in the room also helps there. There are a number of protocols available now. Paul and I were looking at one earlier, which is the Chartered Institute of Arbitrators, has a very helpful protocol out there. Maxwell Chambers in Singapore has a very good offering for online hearings and some good assistance there. So there are lots of places that do this, and you can get examples of the kinds of agreements that you might want to put together or put up, and certainly the kinds of issues that you want to think about leading into it. But I think the key is to be prepared in advance and to make sure you've tested everything in advance and to allow some time for any little issues to be worked out. I don't know if anyone else has any comments on that.
I think that's, go ahead, Paul.
Yeah, the other topic I wanted to talk about in relation to AVLs is something that keeps cropping up about assessing credibility and reliability from a witness who's outside the room. And having done quite a few cases in the High Court where witnesses did give evidence on AVL, I just think that's an overstated concern which really can be put to bed quite quickly. The idea that you can determine credibility by looking at someone or watching body language has been debunked by many of the many literature that's been put out after studies by sociologists in particular. It actually worked out that if you went to a judge, probably you had a 50-50 chance of the judge getting it right if they were just looking at the witness and so forth. The key to determining credibility in this sort of situation should really be to say what facts do the parties agree, what evidence is not in dispute, what evidence does the arbitrator accept from other independent witnesses, and is the evidence consistent or inconsistent with contemporary documents. Now, if you do that analysis, you're more likely to come up with the right answer on credibility or reliability than by looking at someone give evidence, whether it's in a room in which you're also sitting or whether it's on a screen. So I suppose my plea is let's get over that particular issue, because it's certainly one that I've encountered from counsel when any issue of holding a hearing by AVL has been discussed for arbitration purposes.
Panel, I wonder if now might be a time where we could turn to some of the questions that have come up through the Q&A function, and also see whether any of our other attendees would like to put some questions to our panel, or perhaps raise some issues where they'd like some further discussion. So panel, if that's all right with you, some questions coming in. What are the general issues faced during an emergency arbitration procedure? Which is a fairly general question in itself.
It's hard to know whether there are any general issues that are specific to emergency arbitration, rather than the general issues that arise with seeking urgent interim relief anyway. I'm trying to think, apart from, you know, a few things that I flagged, which I don't think are probably very central, about sometimes enforceability if you're trying to do it internationally. I guess you might have general issues around trying to get everything done within the time frame of a very short urgent interim application, but that's an issue that you would have anyway when you're seeking urgent relief. Obviously, for the appointing body, I know that there can be issues in trying to find someone who has the availability to do an emergency arbitration. That can sometimes be difficult because you need someone who can almost drop everything and deal with this very specifically. So that can be a challenge, availability, and I'm sure that's a challenge for council too. But again, those are sort of the challenges that arise when seeking urgent relief generally. I don't know if either Nicole or Paul have any other issues that they can think of.
And I think the only point I would add is that it's very similar to if you file an urgent relief application in the court, and it just gets put on a judge's desk who knows absolutely nothing about the dispute and has to get to grips with it on the papers initially, and particularly if it was a preliminary order or as opposed to an interim relief being made by the emergency arbitrator. There'd also need to be a decision: do I actually need to hear from counsel, or is this something I can actually decide on the papers? in order to get things done quickly. So I think it's just simply that the person who's appointed as an emergency arbitrator will have no knowledge whatsoever, but that would really be the same in the position of an arbitrator who's been there's been a constitution of the tribunal, and he or she's being asked to deal with it quickly.
Nicole, thoughts from you on that?
No, nothing extra to add on the general issues faced during an emergency arbitration procedure.
Thank you. A question, bearing in mind the confidentiality nature of the hearing, do witnesses give evidence under oath? And if so, what are the penalties or remedies, if any, for giving false or misleading evidence? So 2 questions in there.
Paul, I think that's probably, given you're the master of evidence.
I would certainly want all witnesses to give evidence on oath, and my recollection is that if you give evidence on oath in an arbitration, you can be prosecuted for perjury if it's deliberately incorrect. So I think in whatever form of arbitration you have, you're going to be relying on what people say on oath. There may be occasions where, because of the urgency, you might take a statutory declaration or something like that, but that has the same effect. Yeah, I don't think I can take it any further than that.
I've also seen always the witnesses swear some sort of oath or declaration beforehand, and I have seen, just as another perhaps sanction, is sometimes cost sanctions awarded against a party if it's been found that their witnesses were not truthful under oath. So that might be another remedy that's available, a slightly different kind of remedy, but you might get slammed with a very difficult cost award as a result.
Yeah, and that also applies where the evidence doesn't meet the standard of candour that's required for particularly for a without notice application. Costs are invariably awarded if that standard hasn't been met and an order's been made, which, if all information had been available, wouldn't have been made.
The other thing is that if a witness wants to swear rather than give a declaration, then the holy book needs to be where the witness is. So if you don't have the holy book that they choose to swear on, just do a declaration under the Oaths and Declarations Act. Any other questions there? I can see there were some further ones about enforcement of emergency arbitration rulings or decisions. I mean, we are largely focused on arbitrations in New Zealand and emergency arbitrations in New Zealand. So as far as enforcement is concerned, the New Zealand Act has dealt with that. Each jurisdiction will have its own particular quirks as to what it is you can and cannot do in relation to an emergency arbitration award or order or ruling. So the first step is obviously to go to whatever processes you were under. So for example, if it was ICC, I think they specifically state that the emergency arbitrator issues orders. So you have to check that first. And for that, the person asking that question, I would recommend going to the reports of the ICC Task Force on Recognition and Enforcement of New York Convention Awards. There's one of the questions asked of each country that participated was, how do you deal with interim and interlocutory or partial awards in your country? So go to that and you should get an answer, or at least tell you where to look for each country you want to know about. So I can't see any other questions coming up at the moment. I was just going to throw one out to Paul and Anna. Sorry, I haven't, this is not one I prepared earlier. This is one that's occurred to me over the last day. I was just thinking about the option for the litigators who are coming reluctantly to the House of Arbitration and still want the option to duck out and go back to court where they feel more comfortable. I was thinking that one option might be to use an adjudication process. So, and you can craft that as you want to, but adjudication is not just for the builders. It can be crafted up by disputing parties, and it can be a decision issued that is binding until. And the until could be arbitration, or the until could be going back to litigation. What do you think of those options in the COVID environment?
Anna, do you want to go first on that?
Sure. Well, obviously it's an option, and I think the beauty of these things is the flexibility and the ability to craft these things in a way that suit the dispute and suit the parties. I guess there is a sense of, you don't want to craft the dispute in a way that suits the lawyers. You really want to craft the mechanisms in a way that's going to suit the parties and what they're trying to achieve. So if it suits the parties to have that adjudication process, and you're right, it doesn't just need to be in construction. You can craft and agree a process like that yourselves if it's what you want to do. But I guess it would be a shame to do that and put the parties through that and then end up with a non-binding result, and you end up in court or arbitration anyway, just because the lawyers felt a bit reluctant about one process or another. So I do think it's up to us as a profession to make sure we start to get comfortable and to seek advice if we're not comfortable on how to do something, to make sure that what we're doing is the right thing by the parties to get them up and running quickly. And it might be that adjudication, which can be a very quick process, is a good process if they need a quick decision to get up and running. But the parties themselves are a bit worried about getting a binding decision in an expedited manner, and want the option for another shot at it, if you like, if things don't quite go the way they want. But make sure it's what the parties need in their circumstances rather than just what the lawyers want.
Well, one example that I've been involved in is a separate tribunal that's been set up. It's called the Greater Christchurch Claims Resolution Tribunal. Big mouthful, but it deals with some of the residual residential earthquake claims, and it is purely contractual. The people who are the claimants can opt in. There are insurers who are participating. There are some insurers who are not. But basically it is a very streamlined process where the decision maker has a lot of discretion about how to run the process. It is not an arbitration, and it ends up with a binding decision. And the purpose is to run things through in a manner that's not consistent with a court hearing, but allows the issues to be identified, getting in the evidence that's absolutely necessary, deciding the extent to which witnesses need to be heard or cross-examined, putting restrictions where appropriate on the extent of submissions. And obviously the lawyers find this intimidating because it's just not what they're used to. And there's a panel of former High Court judges who are dealing with these, and it's starting to get a bit more frequent in terms of getting to the determination phase, because they have a facilitation phase first, but educating the lawyers that this is actually a process that's designed to deal with this problem quickly is actually probably the most difficult part of it so far.
And could I perhaps ask a question around whether there is a perception at the moment that, you know, we're moving into level 3, business as usual's just over the horizon, let's not worry about emergency arbitration, let's just wait until business as usual. Is that a perception? And if so, do you think it's based in reality, or what are your thoughts on that?
I think whatever level 3 looks like. It's not going to be level 2 and it's not going to be level 1. So even in this small country, if you need to move across regions to be together, then you're not going to be doing that on the 29th of April. So I think that's one thing to think about. And then you need to think about the age of the participants, because if they are over 70, or if they are vulnerable, or if they simply don't feel comfortable with going into a room or a business premises, what you do not want is what you think, everyone thinks is a binding decision, and somebody saying, I do not consider there was natural justice because I didn't come because I felt uncomfortable and nobody was prepared to listen to me.
I think that's absolutely right, Nicole. And I think these restrictions will be with us for some time, the social distancing restrictions. And it may be that in a very small hearing, you could hold it in person with appropriate social distance. But there will be many cases where you can't, or where people just are not comfortable. So I think the idea of these online hearings will be with us for some time because of the conditions we're under. But also, you know, in some ways that can be a blessing in disguise, because there are lots of situations where online hearings might be more appropriate once we get more practiced at them and more comfortable with them, simply because of the cost or various other issues or reasons why bringing everyone together in one room may not be the best route to take in a particular dispute. So getting comfortable with this process that may be applied even when we go back to complete normal, whenever that is, maybe it's a year's time. But having this option available going forward, I think will be very helpful, particularly in these emergency or interim relief situations where flying people around the country for hearings in very short timeframes might really not be worth it. It might be much better to stick with an online platform even then.
Yeah, I suppose my experience so far has been I've had to put off a couple of arbitrations that were going to be heard around well, during the course of the level 4 and also just afterwards. And I think we just have to assume that we're going to have restrictions in the foreseeable future, because we don't yet know what level 3 is going to look like. We'll have an idea in an hour's time. We don't know whether we're going down to level 3, and if so, how long we'll be there. We don't know if there's going to be a second spike like there has been in Singapore, and we might be back in level 4. So I think the discussions at case management has to be about what do we do to get this dealt with on the basis that we're in a restrictive environment. If things change, then let's talk closer to the time about making changes, but let's plan on the basis that we've got a restrictive environment.
So perhaps just one final question then, unless there are any more from the attendees here. I know that the mediation practitioners within AMINZ have been discussing the change in the work that happens ahead of a mediation. Now the time that's being taken up by practitioners in that space is much greater than it was previously with preparing people. Is that the same for the arbitrators practicing? Are you spending more time preparing your participants for your hearings?
And probably in a largest one that's scheduled to take 3 weeks and is quite complex, we've scheduled a conference for next week, and it is a very detailed agenda to cover off all of these sort of things. And a couple of hours have been allowed to go through them. So to that extent, the answer is yes. The degree of preparation is going to be important, because everybody has to buy in to what's going on, or at least have a say in what's going on in terms of what gets ordered. So the mediators have got more complex things like caucusing that yes, they have to try to manage, which arbitrators don't need to concern themselves with. So yes, there's a good deal of preparation required, but perhaps not as much as if you were doing a complex mediation.
And of course, you do need to make sure that you've tested your technology before the hearing starts. Have everyone come up online and make sure everyone can hear each other, see each other, and that the screens are all in the right place.
Mm-hmm.
Requires that extra step.
And then no matter how often you test it, of course, the wretched thing will fall over at 5 minutes to airtime.
That's right. So you need to allow for those things.
That's right.
In your mental state and in your actual scheduling for the day.
Yes, quite right. Nicole, final thoughts to you before I go once around the panel for a wrap.
Well, I think as arbitrators, we are used to moving things forward on the documents and by email, so that hasn't really changed, and we can carry on doing that. We don't have quite the need for the vibe in the room that perhaps you need for a mediation. But having said that, I've got one case which we had a case management conference and everything seemed to be in accordance with a plan, a good plan, and 2 days later we were in lockdown. And so we had another case management conference, and then another 3 days after that, we were in total lockdown. So yes, that's adding to it. You've got to be agile, you've got to be ready to pivot.
Thank you. Panel, I'll just give you the opportunity to close, and then I'll wrap up at the end. So Nicole, any final thoughts before we bid farewell?
A lot of us are making this up as we go along. There are a lot of precedents out there that you can look to, but let's all stay in touch. If you have a good idea, then send it through to Sue. Maybe it's something that we can have a breakfast meeting discussion on. We're all learning as we go, and let's all learn from each other.
Thank you. Anna, how about you?
Yes, I would certainly echo that, and Nicole's earlier words about being able to pivot and be agile at the stage, and my sense is really arbitration's in a good space to do that. We can adjust quite quickly, and we can still get disputes resolved for people during this time. We don't need to stop, we don't need to come to a halt. So as long as we're being a bit flexible with each other, then I think we can still provide the service that we're used to providing, and that hopefully participants still have a good experience of it, even though we've had to juggle things up a bit.
Thank you, Anna. And Paul, over to you.
I think the word Anna used, flexibility for process, is really important, that we've got the flexibility to be able to do things that sometimes the courts can't do. There is a really interesting case study though recently for anybody who's interested in Googling it and finding out. There was a court of protection, which is for vulnerable people, mentally ill people in the UK. And there was a very difficult issue, I think, around life support or something along those lines that had to be dealt with during lockdown. The judge dealt with it entirely over AVL, with expert witnesses, primary witnesses all giving evidence on AVL plus counsel involved. Which just shows it can be done.
Thank you.
In cases where it's needed, it can be done. But if anybody wants to have a look at that online, it's quite an interesting case study. Thank
you, Paul. Well, on behalf of the Institute, could I say thank you very much to our panellists who've so generously given their time today. The Honourable Paul Heath, QC, Dr Anna Kirk and Nicole Smith, who is everywhere these days and doing everything. This webinar will be up online within a couple of days. It's part of our free series that AMINZ is hosting, Doing Business Better in Times of COVID, and a service to our members and at the moment to our invited guests. So we welcome you, we thank you very much for coming, and we hope that this presentation has been useful to you in your practice. Take care and stay well. Goodbye.